to that letter of demand at SM4. Do you see that? Am I right?
Advocate Selo, can we please, I'm asking not to engage with these things because this is about the contract now. And I see it's even on the screen.
I haven't posed the question about the contract.
The issue is being displayed on the monitors, and that issue is currently one of the things on which he's claiming the right to self-incrimination or anything else, but you displayed it and he asked you to take it down.
I see what,
Thank you.
I see what you mean. It has been taken off screen, but just to place on record that this document was displayed and dealt with extensively during the course of Brigadier Majeng's testimony.
May I ask to understand what exactly is the issue about the contract being displayed? There's no question thus far that would tend to implicate Mr. Matlala. I'm not saying you don't have a basis for saying it should be taken off screen, but I want to understand.
Chairperson, the issue was that it was displayed there, and that was what I was trying to convey.
Oh, it's a letter of demand, not the contract.
Yeah, no, but what he was trying to relate to my learned friend was he said, please take it down. It's part of the contract. And my understanding from him is it's one of the issues that I've been dealing with that I said I don't want to answer. So my engagement with my learned friend was that I think she understood it like that is just take it down because it's not something else at this point in time.
Yes.
That was
No. If Ms. Silo has agreed that it should be taken down, I have no problem. But still, I just wanted to understand what the issue is exactly.
Yes, Chair, I think where Ms. Van de Heever is correct, as I understood what she meant. What Mr. Matlala was taking issue with is that it was being flighted. And her interjection was to point out that his request is that it not be flighted. But we are not at a stage of whether or not we deal with it. And it was in response thereto that I said I'm advised that the same document has been dealt with publicly and has been flighted during the testimony of Brigadier Majeng. So that horse has bolted.
Yes, but I think by then Brigadier Majeng was not yet an accused.
Yes, but it's already out in the public arena. There is nothing to protect anymore. Would you accept that?
Myself, I won't accept that because I don't want to be the one who's entertaining that.
No, you have to accept a certain fact. If it was flighted and it's out there, it's out there. It doesn't be out there or not be out there because you, Mr. Matlala, accepts it. Do you understand?
I hear you, Advocate Silo, but I've got an issue with it because I'm the one who's need to account for this thing in court. So I'm kindly asking that it must not be flighted, please.
Then perhaps if you say you have an issue with it, please indicate to the commissioners what your issue with it is.
No, I do not want to engage in anything that is to do with the subcontract in public before I deal with it in court.
But you recall that the chair pointed out that that any right you assert must be in relation to a response to a specific question. You have fallen back into that mode where you are suggesting to the commissioners that a discussion around Medicare 24 is completely off the table. Is that what you're proposing?
Medicare 24 contract,
yes.
Not Medicare 24. I've been engaging with you with Mr. Mutumi.
No.
I'm talking about the contract.
I accept your correction. The contract.
Yes.
Are you suggesting to the commissioners that the contract is off bounds?
No, the contract, I cannot engage in the contract. I cannot engage in that.
So are you invoking, you say you are invoking your right, against self-incrimination each time a reference is made to the contract?
I'm engaging my right in terms of my free trial rights. I do not want to infringe my free trial rights by engaging in my case before I can do that in court.
Your Section 35 rights. So is it your position that any engagement on that contract of any kind before this commission will infringe your rights?
It will, of course.
Why? And how?
Advocate Solam, myself and you now as we sit here, we do not know what is up the sleeves of the prosecutor. We do not know what questions they want to ask or what is their approach. Even myself, you do not know what is my defense strategy. So it's a number of things that can go wrong if we engage in this issue now.
I think I'm having this engagement with you because I'm trying to understand the basis on which you say the Commission cannot engage with that contract at all. You recall yesterday I requested that perhaps to assist the Commission to appreciate the parameters of this right that you assert, that you provide us with the charge sheets in both trials. You recall that?
Yes, I do.
That was a request, and unfortunately, by this morning, you hadn't. By you, I mean collectively with your team, appreciating that.
We got it in the meeting.
Let me just finish, if I may. We have then, in the interim, sought to assist you and have obtained both the charge sheets, and they are part of File 11, Item 3, and Item 7 of File 11. Now, we did that precisely to to understand what charges you face and to inform us and the Commission, generally the commissioners, how far to potentially have a conversation with you about this contract. You understand?
I hear you.
Now, the Medicare charge sheet is at Item 7, appears from page 90.
Sorry again, just for our benefit, which file are we currently?
11. File 11. It's the file that has the SIU order. File 11, page 90, is the charge sheet that was served on you and on the basis of which you are facing the current criminal trial in the Medicare matter.
Yes, I confirm that.
Yes. Now, we had requested that we have this before us so that we look at the various charges preferred against you and or your companies to have an appreciation when you refuse to answer a question as to specifically which offense do you say that question impacts. You remember that?
Yes, I remember that.
Okay. Now, looking then at our page 830, which is that response to the letter of demand for non-performance, what charge in this charge sheet do you suggest that letter impacts and therefore runs the risk of prejudicing you?
Advocate Silo, I will repeat it again that I am not a lawyer, so I do not know the tactics of lawyers. How do they approach their cases? So I just want to be on a safe side by not approaching anything that has to do with this thing.
Because the approach you want to adopt is precisely the approach that I think the chair cautioned against, which is you can't be suggesting a blanket ban on conversation around the subcontract. And that any asset, any right you seek to assert must be in response to a specific question. And I'm suggesting to you to assist you to determine when it is to invoke your rights. Perhaps reference to the charge sheet would assist you because the charge sheet specifies the different offenses for which you are charged.
Chairperson, may I at this stage just try and briefly deal with one of the issues that I find difficulties with right at this point. Mr. Matlala has indicated to your honourable self and your fellow commissioners that he's invoking his fair trial right. He's also indicated to you that he's not a lawyer and he doesn't know, simply put, about how lawyers deal with these various issues. I understand the approach you've discussed yesterday with reference to paragraph 109 and what's further. And I go back to maybe a little bit to what I've referred to earlier today. When one deals with somebody's Section 35 rights, it goes much further than purely the right to self-incrimination, which is the right that you're being afforded under the 47 Act. There's a right that you've got, for instance, to adduce, and put it the other way around, to challenge and produce evidence. There's a right to challenge inadmissible evidence, etc., etc. Now, those rights, you cannot simply ascertain by looking at an indictment or at a charge sheet. Those are issues, legal issues, evidentiary issues that's dealt with by counsel and attorneys during the course of a trial. So what I'm saying to you, and again with respect, not in the sense that you think I'm doing it, I'm saying this really with respect, is that to say that you have to revert to the judgment wherein Mr. Chief Justice Yafta gave the judge. If you look, for instance, I think it's paragraph 111, he clearly states that what he says in 109, he deals with specifically in relation to the fact that Mr. Zuma was subpoenaed at that point. At no stage, and please, if you can, if I do understand this judgment correctly, I would bow to your superior interpretation of this. But this judgment at no stage dealt with your other constitutional rights. At the time, as I said to you, when Section 3(4) was enacted in the Commissions Act, there was no such thing as a constitution. We didn't have a constitution that's been time and time ruled by the Constitutional Court to be the superior law of the country. Those fair trial rights that an accused person or a suspect down the line can assert in a court of law has been crystallized almost on a case-to-case basis and very often goes beyond what is contained in Section 35. I cannot foresee any situation where where Section 3(4) of the Commissions Act would simply swipe away or brush aside you as an accused person ascertaining before a commission of inquiry your other rights under Section 35. More so because that's not a right. Your Section 35 rights is not suspended or cease to exist the moment you, for instance, appear before the commission. Those are rights that you can invoke consistently. Because what we've got now, and I've not come across a case, and as I said, Zuma's case is a totally different kettle of fish, where a person that sits in Mr. Matlala's position had to invoke these rights. It's been dealt with in other forums. But right now, and it goes back to maybe where we started this morning, it's not, it doesn't fall within, I would respectfully submit, his realm of knowledge as a legal practitioner to understand exactly what rights can be invoked at which specific time. That's why I go and I say the rights that you are entitled to as an accused person and a suspect are far wider than the single right that you are afforded under 3(4) of the Commissions Act. And to ask him to now go with specific reference to that and to that issue that's referenced in a single paragraph that's maybe explained is, I respectfully submit, unfair for the reasons that I've submitted to you right now. Because it's not, let me stop there at this point.
Yesterday, when there was particular focus on paragraph 109, what was claimed was the privilege against self-incrimination. You are making a different point, which refers to Section 35 of the Constitution. But what I would say to you, I'm yet to give Ms. Silva an opportunity to respond. But what I would raise with you is this. Even the Section 35 rights, one cannot raise them in the air, so to speak. I've had a cursory look at this letter. I cannot claim to have read it so thoroughly that I was in a position to follow everything contained in it. It's quite a lengthy letter, and it's not that succinct. And, I do not understand how, and you would have to explain to me how the Section 35 right, the fair trial right, is implicated. I just do not see how. I'm saying how that right would be implicated. Of course, not in these proceedings, but you mean in the criminal proceedings implicated by what happens here. So what I'm saying is I do not see how it will be or would be implicated by what happens here, reference being made to this letter, you would have to address us specifically and not just argue a legal point in the air, so to speak. So you would have to make specific reference to this letter. This letter says this and that and that and that, and for that reason, Mr. Matlala's fair trial right will be implicated. That's where your submissions are seriously lacking.
Indeed, if, as I said, if that is what you expect of me, I would, I don't know what the time is now, I will address you on that issue first thing in the morning. I think we've got enough to continue with specific reference to each and every of the points that was inter alia made by Mr. Matlala in the supplementary affidavit, and expand on that with hopefully the bit of legal knowledge I have.
No, I will not let you off on this, Ms. van den Heever. You have interjected and made legal submissions when questions were being asked around this letter. You could only have been able to do that if you are in a position to answer my question now. Otherwise, you are, as I said earlier, you are raising your legal point hypothetically or in the air, as I say. And you could only do that if you are in a position to address us on the contents of this letter. If you are not, you had no basis whatsoever to raise the legal point. So I would want you to address us now, not tomorrow. I would want you to address us now on this issue. If you say you are only ready tomorrow, why then did you raise the legal point? Because it ought not, from where you are sitting now, it ought not to have arisen at all. Or may I say this? Or what you should rather have said, maybe let me not get there. Let me just end it saying, I will not let you off that easily.
No,
yes.
I can address you on the specific points that I believe is relevant and that was raised by him in his affidavit, the supplementary affidavit, and I can raise this specifically to the manner in which those issues are raised as you've invited me to in a criminal trial vis-a-vis the proceedings in this particular case. I'm
saying now, and you say only tomorrow. I'm saying, tell us how those fair trial rights are implicated in respect of this letter, and I'm inviting you to address me on that now.
And Chairperson, maybe we're speaking past each other at this point. He was asked, from my understanding, to utilize the indictment that was there, that was referenced by my learned friend, and to deal with it. And his answer to that is that I cannot deal with this indictment because I'm not a legal person. So that's why I said maybe we're speaking past each other at this point in time, because I was addressing the fact you cannot give a person an indictment and say, use your indictment now and answer the questions.
I will seek clarity from Ms. Sillo unless I misunderstood, and if I did, I will withdraw everything that I have said.
I misunderstood what she said. I will also look at the deal with it.
All right, okay.
I understood it, but
Let me say this. Yes, I understood Ms. Sillo's reference to the indictment, but I understood Ms. Sillo to get to the indictment springing from the contents of this letter. So what Ms. Sillo appeared to me to be saying was, let's engage you, Mr. Matlala, on this letter. But because you are talking fair trial rights or whatever else, now let's look at the indictment and see how it becomes relevant to the contents of this document. So now when you make your submissions about the fair trial rights, I say fine, well and good, but make those submissions in relation to this letter. Please correct me. I will immediately withdraw, Ms. Sillo.
There is nothing to correct here, because that is exactly what I said. In fact, the reference to the charge sheet was in a bid to assist, so that we do not unduly stray and be confronted with these responses.
Then I will also withdraw the submissions I made right now. Maybe I can, in fact, this particular question to the letter, and what my learned friend has tried to indicate to my client about the use of this letter, maybe if I can get a very short few minutes, I can try and explain to him some of the issues that was raised by my learned friend as to why she says she can ask him about it at this point. I think I could cut through unnecessary objections at this stage, if that is the only issue.
Let's rather see the evidentiary matter that Ms. Silo can engage with. 4 o'clock is not that far away from now. Let's just continue, see how things go, Ms. Fanny, rather than take it.
As I said, because I thought we could cut through this, because I understand where she comes from, and I think it's a simple explanation to the client might curtail her reasoning why she can and why she argues that it is already out in the public, and I can explain to him as to...
Let's just see how things go. Let's just see how things go. 4 o'clock, we'll adjourn, and you'll have the time to do whatever you want.